I read about torts. Torts. I'm actually going to start with defenses to intentional torts, and that's module 4. And starting with 4.1, consent. The plaintiff's consent to the defendant's conduct is a defense, but the majority view is that one cannot consent to a criminal act. Any consent fact pattern raises 2 questions. Was there a valid consent? Did the defendant stay within the boundaries of the consent? Capacity required. Individuals without capacity are deemed incapable of consent. For example, drunken persons and very young children, persons with limited capacity, such as older children and persons with mild intellectual abilities, can consent, but only to things within the scope of their understanding. Express actual intent. A defendant is not liable if the plaintiff expressly consents to the defendant's conduct. Exceptions: 1. Mistake will undo express consent if the defendant knew and took advantage of the mistake. 2. Consent induced by fraud will be invalidated if it goes to an essential matter, but not a collateral matter. And 3. Consent obtained by duress will be invalidated unless the duress is only threats of future action or future economic deprivation. Be so dry. Implied consent. Apparent consent is that which a reasonable person would infer from custom and usage or the plaintiff's conduct. For example, normal contacts inherent in body contact sports, ordinary incidental contact, etc. Consent implied by law arises when action is necessary to save a person's life or for some other important interest in person or property. Exceeding consent given. If the defendant exceeds the scope of the consent by committing a more intrusive invasion or by invading a different interest than the one the plaintiff referenced, they may be liable. Protective privileges. When a question involves the defense of others, self, others, or property, the following 3 questions. Is the privilege available? These privileges apply only for preventing the commission of a tort. Already committed torts do not qualify. Is a mistake permissible as to whether the tort being defended against, battery, trespass, etc., is actually being committed, and was a proper amount of force used? Self-defense. When a person reasonably believes they are being won or are about to be attacked, they may use such force as reasonably necessary to protect against injury. When is defense available? The majority rule is that there is no duty to retreat. The modern trend imposes a duty to retreat before using deadly force, if this can be done safely, unless the actor is in their home. Self-defense is not available to the initial aggressor unless the other party responds to the aggressor's non-deadly force by using deadly force. Self-defense may extend to third-party injuries caused while the actor was defending themselves. An actor might be liable to a third-party person if they deliberately injured the third person in trying to protect themselves. Is mistake allowed? A reasonable mistake as to the existence of a danger is allowed. How much force is used? One may use only that force that reasonably appears to be necessary to prevent the harm, including deadly force. If more force than is reasonably necessary is used, the defense is lost. And page 16, defense of others. when a defense is available, one may use force to defend another when they reasonably believe that the other person could have used force to defend themselves. Is mistake allowed? A reasonable mistake as to whether the other person is being attacked or has a right to defend themselves is permitted. How much force may be used? The defender may use as much force as they could have used in self-defense if they were the one threatened with the injury. Defense of property. When is defense available? One may use reasonable force to prevent the commission of a tort against their real or personal property. A request to desist or leave must first be made unless it clearly would be futile or dangerous. The defense does not apply once the tort has been committed. However, one may use force in hot pursuit of another who has tortiously dispossessed the owner of their chattels because the tort is viewed as still in progress if the defendant is in the act of fleeing. Is mistake allowed? A reasonable mistake is allowed as to whether an intrusion has occurred or whether a request to desist is required. A mistake is not allowed as to whether the entrant has a privilege, for example, necessity, that supersedes the defense of property right, unless the entrant conducts the entry so as to lead the defendant to reasonably believe he is not privileged, such as by refusing to say what the necessity is and how much force may be used. Reasonable force may be used, however, one may not use force causing death or serious bodily harm unless the invasion of property also entails a serious threat of bodily harm. The same principle makes it impermissible to set deadly mechanical devices or tips such as spring guns to protect property. Shoplifting detentions. A shopkeeper has a privilege to detain a suspected shoplifter for investigation. For the privilege to apply, the following conditions must be satisfied. There must be a reasonable belief as to the fact of theft. The detention must be conducted in a reasonable manner, and only non-deadly force can be used. The detention must only be for a reasonable period of time and only for the purpose of making an investigation. Reentry onto land. At common law, one could use force to re-enter land only when an intruder came into possession tortiously, such as by trespass. Under modern law, there are summary procedures such as ejectment for recovering possession of real property. Hence, resort to self-help is no longer allowed. Recapture of chattels. The basic rule is the same as that for reentry of land at common law. When another's possession began lawfully, for example, a conditional sale, one may use only peaceful means to recover the chattel. Reasonable force may be used to recapture a chattel only when in hot pursuit of one who has obtained possession wrongfully, for example, by theft. Necessity. A person may interfere with the real or personal property of another when it is reasonably and apparently necessary in an emergency to avoid injury from a natural or other force, and when the threatened injury is substantially more serious than the invasion that is undertaken to avert it. There are two types of necessity: public necessity and private necessity. A defendant can raise public necessity as a defense if they acted to avert an imminent public disaster. Private necessity can be defense when the action was to prevent serious harm to a limited number of people. On a private necessity, the actor must pay for any injury unless the act was to benefit the property owner. And so a necessity is a defense only to property torts. We got to Module 5, the general duty of care and negligence. Making it hot in here by boiling water. Why?
Oh, I was expecting to hear it. Sorry.
No, I don't have the thing with them.
Shoot, sorry about that. Yeah.
He's just hot.
Pour some before I lay down. And I thought I was going to whistle.
The general duty of care and negligence. The Elements of a prima facie case of negligence are a duty on the part of the defendant to conform to a specific standard of conduct for protection of the plaintiff against unreasonable risk of injury. 2, a breach of that duty by the defendant. And 3rd, the breach is the actual and proximate cause of the plaintiff's injury. And 4th, damages. A duty of care is owed to all foreseeable plaintiffs if the defendant's conduct creates an unreasonable risk of injury to the persons in the position of the plaintiff. The general duty of care extends from the defendant to the plaintiff. The extent of the duty is determined by the applicable standard of care. Therefore, when confronted with a negligence question, you should always ask, to whom do you owe a duty? What is the applicable standard of care? Duty of care owed only to foreseeable plaintiffs. A duty of care is owed only to foreseeable plaintiffs, the class of persons who were foreseeably endangered by the defendant's negligent conduct. Rescuers. A rescuer is a foreseeable plaintiff when the defendant negligently put themselves or a third person in peril. Danger invites rescue. Firefighters' rule. Firefighters and police officers are barred by the firefighters' rule from recovering for injuries caused by the inherent risks of their jobs. Prenatal injuries. A duty of care is owed to a viable fetus in cases of failure to diagnose a congenital defect or properly perform a contraceptive procedure. The child may not recover for wrongful life, but the parents may recover damages in a wrongful birth or wrongful pregnancy action for any additional medical expenses and for pain and suffering from labor. Ordinary child rearing expenses, however, cannot be recovered. Intended beneficiaries of economic transactions. A third party for whose economic benefit a legal or business transaction was made, for example, a beneficiary of a will, may be a foreseeable plaintiff. Basic standard of care, the reasonably prudent person. All persons owe a duty to behave with the same care as a hypothetically reasonable person, prudent person, in the conduct of their activities to avoid injuring foreseeable victims. The reasonably prudent person standard is an objective standard measured against what the average person would do. A defendant's mental deficiencies and inexperience are not taken into account. In other words, low intelligence is no excuse. Exception for superior skill or knowledge. While the reasonably prudent person standard sets a minimum level of care, a defendant who has knowledge or experience superior to that of an average person is required to exercise that experience. Exception for the physical characteristics where relevant. The reasonably prudent person is considered to have the same physical characteristics as the defendant if those physical characteristics are relevant to the claim. But remember, one is expected to know one's physical abilities and to exercise the care of a person with such knowledge. For example, a blind person should act as a reasonably prudent person who cannot see and not attempt, for instance, to drive a car. Module 6, special negligence duties based on the type of defendant. Children are held to a standard of care of a child of like age, intelligence, and experience. This is a subjective test. A child under 5 is usually without the capacity to be negligent. Children engaged in potential dangerous adult activities may be required to conform to an adult standard of care. Professionals. A professional is required to possess the knowledge and skill of an average member of the profession or occupation in good standing. For doctors, most courts apply a national standard of care to evaluate their conduct. Duty to disclose facts of treatment. A doctor has a duty to disclose the risks of treatment to enable a patient to give an undisclosed risk, to give informed consent. A doctor breaches this duty if an undisclosed risk was serious enough that a reasonable person in the patient's position would have withheld consent on learning of the risk. Possessors of land. Under the traditional rule followed in many states, The duty owed a plaintiff on the premises for dangerous conditions on the land depends on the plaintiff's status as unknown trespasser, known trespasser, licensee, or invitee. Unknown trespassers. No duty is owed to an undiscovered trespasser. Known trespassers. As to discovered or anticipated trespassers, the land possessor must warn or make safe any conditions that are artificial, highly dangerous, involving risk of death or serious bodily harm, concealed, known to the land possessor in advance. Licensees. A licensee is one who enters the land with the possessor's permission for their own purpose or business rather than for the possessor's benefit. Social guests are considered licensees. Although firefighters and police officers are typically licensees because they often enter property with implied consent. On public policy grounds, they are owed no duty of care regarding risks that are inherent in their job. As to licensees, the land possessor has a duty to warn or to make safe hazardous conditions that are concealed, known to the possessor in advance, and those are the only two requirements. The land possessor must exercise reasonable care in the conduct of active operations on the property. The possessor has no duty to inspect or repair. Invitees enter onto the land in response to an invitation by the possessor of the land, meaning they enter for a purpose connected with the business of the land possessor, or enter as members of the public for a purpose for which the land is held open to the public. An invitee will lose invitee status if they exceed the scope of their invitation. The landowner or occupier owes a duty to invitees regarding hazardous conditions that are concealed, known to the land possessor in advance, or could have been discovered by a reasonable inspection. Trespassing children, attractive nuisance doctrine. Most courts impose on the landowner the duty to exercise ordinary care to avoid a reasonably foreseeable risk of harm to children caused by dangerous artificial conditions on their property. To establish the doctrine's applicability, the plaintiff must show a dangerous condition on the land that the owner should be aware of. The owner is likely to cause injury. It is dangerous because the child's inability to appreciate the risk. The expense of remedying the situation is slight compared with the magnitude of the risk. Those are the four considerations. So, a dangerous condition on the land that the owner should be aware of. They should know the children might trespass on the land. The condition is likely to cause injury. It is dangerous because of the child's inability to appreciate the risk, and the expense of remedying the situation is light compared to the magnitude of the risk. There's a table on page 25 of duties owed at the top and the status of the entrant on the right, left. And so the duties owed under art for undiscovered trespassers is no duties across the board, whether it's artificial conditions, natural conditions, or active operations. I think that's what that says, active operations. Active operations. Whereas discovered or anticipated trespassers, as it relates to artificial conditions, the duty is to warn of or make safe known conditions if non-obvious and highly dangerous. There's no duty for natural conditions, and for active operations, there is a duty of reasonable care. For a licensee, under the traditional rule, which includes a social guest, the duties owed for artificial conditions is a duty to warn of or make safe known conditions if non-obvious and dangerous. For natural conditions, the same is the duty owed, and for active operation, there's a duty of reasonable care. Invitees are, under the traditional rule, includes members of the public, business visitors, as it relates to artificial conditions and natural conditions. The duty is the same: to make reasonable inspections to discover non-obvious dangerous conditions and warn or make them safe. And again, there's a duty of reasonable care for active operations. Page 26. Duty owed to users of recreational land. A landowner who permits the general public to use their land for recreational purposes without charging a fee is not liable for injuries suffered by a recreational user unless the landowner willfully and maliciously failed to guard against or warn of a dangerous condition or activity. Duty of possessor to those off premises. There generally is no duty to protect someone off the premises from natural conditions on the premises. However, there is a duty for unreasonably dangerous artificial conditions or structures abutting adjacent land. Also, one must carry on activities on the premises so as to avoid unreasonable risk of harm to others off the premises. Duties of lessor and lessee of realty. The lessee has a general duty to maintain the premises. The lessor must warn of existing defects of which they are aware, or have reason to know, and which they know the lessee is not likely to discover on a reasonable inspection. If the lessor covenants to repair, they are liable for unreasonably dangerous conditions. If the lessor volunteers to repair and does so negligently, they are liable. Duties of vendor of realty. A vendor must disclose to the vendee concealed unreasonably dangerous conditions of which the vendor knows or has reason to know, and which the vendor knows the vendee is not likely to discover on a reasonable inspection. Module 7, other special negligence duties. There's statutory standards of care, a clearly stated specific duty imposed by the statute providing for criminal penalties, including fines for regulatory offenses and ordinances, such as for speeding, and replace the more general common duty of care if the plaintiff is within the protected class. The statute was designed to prevent the type of harm suffered by the plaintiff, and excuse for violation. Violation of some statutes may be excused where compliance would cause more danger than violation, or where compliance would be beyond the defendant's control. Effective violation or compliance. Under the majority view, an unexcused statutory violation is negligence per se. In other words, it establishes the first two requirements in the prima facie case, a conclusive presumption of duty and breach of duty. In contrast, even though violation of the applicable statute may be negligence, compliance with the statute will not necessarily establish due care. Page 28. Affirmative duties to act. Generally, one does not have a legal duty to act. There is no duty to rescue. Exceptions, special relationship between the parties. A special relationship between the parties, for example, parent-child, may create a duty to act. Similarly, common carriers, innkeepers, shopkeepers, and others that gather the public for profit owe duties of reasonable care to aid or assist their patrons. In addition, places of public accommodation have a duty to prevent injury to guests by third persons. Exception, peril due to own conduct. One has a duty to assist someone they have negligently or innocently placed in peril. Assumption of duty by acting. One may assume a duty to act by acting. For example, once a defendant undertakes to aid someone, they must do so with reasonable care. Exception, many states have enacted Good Samaritan statutes, which exempt doctors, nurses, etc. from liability for ordinary but not gross negligence. Duty to prevent harm from from third persons. Generally, there is no duty to prevent a third person from injuring another, and an affirmative duty may be imposed. However, if one has the actual ability and authority to control a person's actions and knows or should know the person is likely to commit acts that would require exercise of this control. Other particular standards of conduct. Common carriers and innkeepers. Common carriers and innkeepers are held to a very high degree of care, meaning they are liable for slight negligence. Automobile driver to guest. A guest in an automobile is owed a duty of ordinary care. In a few statutes states one is liable to non-paying passengers only for reckless tortious conduct. Bailment duties. In a bailment relationship, the bailor transfers to the bailee possession of the chattel but not title. For example, bailor loans their car to bailee. Duties owed by bailee. The bailee's standard of care depends on who benefits from the bailment. 1, for a sole benefit of the bailor bailment, there is a low standard of care. 2, for a sole benefit of the bailee bailment, there is a high standard of care. And 3, for a mutual benefit bailment, typically a bailment for hire, there is the ordinary care standard. The modern trend applies a duty of ordinary care under the circumstances whereby the type of bailment is just one factor taken into account. Duties owed by bailor. For a sole benefit of the bailee bailment, the bailor must inform the bailee of known dangerous defects in the chattel. For a bailment for hire, the bailor must inform the bailee of chattel defects of which they are or should be aware. Emergency situations. A defendant must act as a reasonably prudent person would under the same emergency conditions. The emergency is not to be considered, however, if it is the defendant's own making. Module 8, negligent infliction of emotional distress. Near miss cases, the duty to avoid negligent infliction of emotional distress may be breached when the defendant creates a foreseeable risk of physical injury to the plaintiff. The plaintiff usually satisfies 2 requirements to prevail. 1, the plaintiff must be within the zone of danger. 2, the plaintiff must suffer physical symptoms from the distress. The plaintiff must be within the zone of danger. The plaintiff will be considered to be within the zone of danger of the defendant's negligent acts when the plaintiff is sufficiently close to the defendant such that they are subject to a high risk of physical impact. And plaintiff must suffer physical symptoms from the distress. In a near-miss case, most courts require that the emotional distress caused by the defendant's conduct manifests itself in physical symptoms. Note that severe shock to the nervous system that causes physical symptoms will satisfy this requirement. A growing minority of states have dropped the requirement of physical symptoms. Bystander cases. A bystander outside the zone of danger of physical injury who sees the defendant negligently injuring another can recover damages for their own distress as long as the plaintiff and the person injured by the defendant are closely related. The plaintiff was present at the scene of the injury and potentially or personally observed or perceived the event. Most states drop the requirement of physical symptoms in this situation. Special relationship between the plaintiff and the defendant. The defendant may be liable for directly causing the plaintiff severe emotional distress when the duty arises from the relationship, typically commercial in nature, between the plaintiff and the defendant, such that the defendant's negligence has great potential to cause emotional distress. For example, doctors misdiagnosis the patient has terminal illness, mortuary's negligent cremation of deceased contrary to family's instructions. Most states drop the requirement of physical symptoms in this situation as well. So there's a table on page 32 for intentional infliction of emotional distress compared to negligent infliction of emotional distress on a couple key points. For the conduct required in an intentional and an IIED case, the conduct has to be extreme and outrageous. In negligent infliction of emotional distress, NIED, this subjects the plaintiff to a threat of physical impact or severe emotional distress likely to cause physical symptoms. The degree of fault required for IIED is intent to cause severe emotional distress or recklessness as to the effect of the conduct. And for NIED, negligence is the standard of fault required, and negligence particularly in creating a risk of physical injury to the plaintiff. Causation and damage. Defendant's conduct must cause severe emotional damage in IIED, whereas in NIED, the defendant's conduct generally must cause physical symptoms from the distress. Growing minority of states drop this requirement. And the bystander recovery in IIED, the plaintiff bystander must be present when the conduct occurs. The distress must result in bodily harm, or plaintiff must be a close relative of the third party, and third defendant must know these facts or have intent to cause plaintiff distress. Whereas in NIED, bystander recovery, the plaintiff bystander must 1, be closely related to the injured person, 2, be present at the scene, and 3, observe or perceive the injury. Moving on to Module 9, breach of duty and negligence, page 33. When the defendant's conduct falls short of that level required by the applicable standard of care owed to the plaintiff, the defendant has breached their duty. Whether the duty of care is breached in an individual case is a question for the trier of fact. The plaintiff may use one of the following theories to show proof of the breach: custom or usage. When the standard of care is reasonable prudence, evidence of the customary usage of others may be used to establish how a reasonable person should have behaved under the circumstances. However, this evidence is not conclusive on the question of whether certain conduct amounted to negligence. For example, although certain behavior is custom in an industry, a court may find that the entire industry is acting negligently. Violation of statute, where the duty of care is set by a statute under the rules that govern using statutes in negligence litigation. Proof of violation of the statute is conclusive evidence of breach of duty. This is known as negligence per se. Causation of damages must still be established by the plaintiff. Right, ipsa loquitur. In some cases, the very occurrence of an event may tend to establish a breach of duty. The doctrine of re ipsa loquitur requires the plaintiff to show that an accident causing injury is a type that would not normally occur unless somebody was negligent, and the negligence is probably attributable to the defendant, meaning that this type of accident ordinarily happens because the negligence of someone in the defendant's position. This often can be shown by evidence that the instrumentality causing the injury was in the exclusive control of the defendant. Effect of re ipsa loquitur. Where re ipsa loquitur is established, the plaintiff has made a prima facie case and no directed verdict may be given for the defendant. The plaintiff may still lose, however, if the inference of negligence is rejected by the trier of fact. Occasionally, the plaintiff may also move for a directed verdict. The plaintiff's motion should always be denied, except in the rare case where the plaintiff has established negligence per se through violation of the applicable statute and there are no issues on proximate cause. So I'm actually going to enter my own exam tip that re ipsa loquitur is in this breach section. whereas negligence per se is in the duty section, and that's for a reason. So they're kind of crossing over here in the breach section when the breach is trying to talk about avoidance of directed verdict. They're not able to do so in a vacuum that pertains solely to breach. So they're talking also about the duty that's breached, and that can be established, both elements that is, by negligence per se. Whereas re ipsa loquitur does not deal with or isn't part of the analysis of whether or not there's a duty. It should be analyzed in the breach section. It's something I learned and have to remember. Recently learned and have to remember. Module 10 is factual causation. There's another thing to keep straight is that foreseeable plaintiffs is part of whether or not a duty arises, but foreseeability is going to come up in this factual causation, and so not to forget that. You might be using that word in two different sections of the negligence analysis. Once negligent conduct is shown, a breach of the standard of care owed a foreseeable plaintiff, the plaintiff must show that the conduct was the cause of the injury. For liability to attach, the plaintiff must show both factual and, which is actual cause, and proximate cause. Several tests exist for determining if the defendant's conduct is the factual cause of the plaintiff's injury. So, factual cause is tested by the but-for test. An act or omission is a factual cause of an injury when the injury would not have occurred but for the act or omission. This test applies where several acts, each insufficient to cause the injury alone, contribute or combine to cause the injury. A defendant can refute this by showing that the plaintiff would have still been injured even if the act or omission did not occur. Merged causes is the next section in this section, in this module, where several causes bring about the injury and any one alone would have been sufficient to cause the injury. The defendant's conduct is the cause in fact if it was a substantial factor in causing the injury. Some courts refer to the situation as one involving multiple sufficient causes. So I'm going to move on to the next page, but those are two different tests, but for and substantial factor tests and merge causes. Unascertainable causes approach. This test applies when there are two acts, only one of which causes the injury, but it is not known which one. The burden of proof shifts to the defendants, and each must show that his negligence is not the actual harm, not the actual cause. This is the Summers v. Tice case in California, where two hunters shot the third hunter while quail hunting, and they really couldn't tell who did it. But let's see if the other case isn't cited here for merged causes, but it does talk about a conflagration of two fires, and I can't remember the case name at this time. Proximate causation, module 11. In addition to being a cause in fact, the defendant's conduct must also be the proximate cause of the injury. Even though the conduct actually caused the plaintiff's injury, it might not be deemed to be the proximate cause. Thus, the doctrine of proximate causation is a limitation of liability and deals with liability or non-liability for unforeseeable or unusual consequences of one's acts. General rule, scope of foreseeable risk. A defendant generally is liable for all harmful results that are the normal incidents and within the increased risk caused by their negligent acts. This is the foreseeability test. Common foreseeable intervening forces. The defendant is liable when their negligence caused a foreseeable reaction from an intervening force or created a foreseeable risk that an intervening force would harm the plaintiff. The following intervening forces that are normal responses or reactions to the situation created by the defendant's negligent act are almost always foreseeable. They include medical malpractice, negligence of rescuers, protection or reaction forces to the defendant's conduct, including efforts to protect person or property, disease or accident substantially caused by the original injury, intervening forces that are not just a natural response or reaction to the situation caused by the defendant's conduct may be foreseeable if the defendant's negligence increased the risk of harm from these forces. These intervening forces include 1. Negligent acts of third persons, 2. Crimes and intentional torts of third persons, and 3. Acts of God. For example, if a valet leaves the keys in a car and a thief steals the car, the valet may be liable because the thief's conduct may be considered a foreseeable intervening cause. Compare superseding forces. Intervening forces that produce unforeseeable results not within the increased risk created by the defendant's negligence are generally deemed unforeseeable and superseding. Superseding forces break the causal connection between the defendant's initial negligent act and the plaintiff's ultimate injury, thus relieving the defendant of liability. For example, to take an alternate road and then another driver negligently collides with the plaintiff on this road, the other driver's conduct is an unforeseeable intervening force because the defendant's negligence did not increase the risk of its occurrence. Thus, the other driver is superseding force that cuts off the defendant's liability for the original negligent act of blocking the road. Damages and defenses to negligence. This is Module 12. Damages. Damage is an essential element of negligence. It's the fourth and final essential element of negligence. Thus, damage will not be presumed, and nominal damages are not available. In all cases, the defendant takes the plaintiff as they find the plaintiff, meaning the defendant is liable for all damages, including aggravation of an existing condition, even if the extent or severity of the damages was unforeseeable. This is also known as the eggshell skull plaintiff rule. Personal injury. The plaintiff is to be compensated for all their damages, past, present, and prospective, both economic damages such as medical damages and non-economic damages such as pain and suffering. A plaintiff suffering physical injury may also recover damage for any resulting emotional distress. Property damage. The measure of damage is the reasonable cost of repair, or if the property is totally or nearly destroyed, its fair market value at the time of the accident. Emotional distress damages generally cannot be recovered for negligent harm to property. Under this last stated rule, a person cannot recover for emotional distress if another party negligently injures or kills their pet. Punitive damages. Punitive damages generally are not available in negligence cases. However, a plaintiff may recover punitive damages if defendant's conduct is wanton and willful, reckless, or malicious. Non-recoverable items. They include the interest from the date of damage in the personal injury action, sometimes called prejudgment interest, and 2, attorney's fees. Duty to mitigate. In all cases, the plaintiff has a duty to take reasonable steps to mitigate damages, for example, seek appropriate treatment. Collateral source rule. Damages are not reduced just because the plaintiff received benefits from other sources, for example, health insurance. Contributory negligence. Contributory negligence is negligence on the part of the plaintiff that contributes to the plaintiff's injuries. The standard of care for contributory negligence is the same as the ordinary negligence. Hence, a rescuer will not be deemed contributorily negligent without taking into account the emergency situation. Also, the plaintiff's violation of an applicable statute may be used to establish their contributory negligence. Defense to So contributory negligence, again, is a defense to defendant's violation of the statute. Contributory negligence is a defense to negligence proved by the defendant's violation of an applicable statute unless the statute was designed to protect the class of plaintiffs from their incapacity and lack of judgment. For example, a child injured after darting into a street in a school zone and getting hit by a speeding car of the defendant. No defense for intentional torts. Contributory negligence is not a defense to wanton willful misconduct or intentional tortious conduct. Effective contributory negligence. Contributory negligence completely barred the plaintiff's right to recover at common law. However, almost all jurisdictions now favor a comparative negligence system, see below. Last clear chance, an exception to contributory negligence. Last clear chance permits a plaintiff to recover despite their contributory negligence. Under this rule, a person with the last clear chance to avoid an accident who fails to do so is liable for negligence. Last clear chance is established, or essentially the plaintiff's rebuttal to the defense of contributory negligence. Helpless peril, inattentive peril, prior negligence cases. In helpless peril in many states, if the plaintiff is in helpless peril, the defendant will be liable if they knew or should have known of the plaintiff's predicament. And in inattentive peril situations, that is where the plaintiff could have extricated themselves. If attentive, the defendant must actually have known of the plaintiff's predicament. Prior negligent cases, for the last clear chance doctrine to apply, the defendant must have been able but failed to avoid harming the plaintiff at the time of the accident. If the defendant's only negligence occurred earlier, the doctrine will not apply. Imputed contributory negligence, assumption of risk. So this is the last part of contributory negligence. Is, as a general rule, the contributory negligence of a third party will be imputed to the plaintiff and bar the plaintiff's claim only when the relationship between the third party and the plaintiff is such that a court could find the plaintiff vicariously liable for the third party's negligence. Negligence is imputed in employer-employee, partner, and joint venture relationships. Negligence is not imputed between spouses, parent, and child, automobile owner, and driver. Lastly, assumption of risk. The plaintiff may be denied recovery if they assume the risk of any damage caused by the defendant's act. The plaintiff must have known of the risk and voluntarily proceeded in the face of the risk. Implied assumption of risk. Knowledge may be implied where the risk is one that an average person would clearly appreciate. The plaintiff may not be said to have assumed the risk where there is no available alternative to proceeding in the face of the risk or in situations involving fraud, force, or an emergency. Also, common carriers and public utilities may not limit their liability by disclaimer, and members of the class protected by statute will not be deemed to have assumed any risk. Express assumption of risk. The risk may be assumed by express agreement. No defense to intentional torts. Assumption of risk is not a defense to intentional torts, but it is a defense to wanton or willful misconduct. Comparative negligence. This is actually the last section for negligence. Defenses to negligence. Surprisingly, there are defenses to negligence. Some comparative negligence. In comparative negligence states, the plaintiff's contributory negligence is not a complete bar to recovery. Rather, the trier of fact weighs the plaintiff's negligence and reduces damages accordingly. For example, if the plaintiff is 10% at fault, their damages are reduced by 10%. There are no rules governing the assignment of fault. The numbers are left to the discretion of the jury. A majority of states have adopted partial comparative negligence, which still bars the plaintiff's recovery if their negligence was more serious than that of the defendant's negligence, or in some states at least as serious as the defendant's. If more than one defendant has contributed to the plaintiff's injury, the plaintiff's negligence will be compared with the total negligence of all defendants combined. States that have adopted pure comparative negligence allow recovery no matter how great the plaintiff's negligence was. Here to assume pure comparative negligence applies unless a question in the MBE states otherwise. And the effect of other doctrines. The last clear chance assumption of risk, wanton or willful conduct. The last clear chance is not used in comparative negligence jurisdictions. Assumption of risk, express assumption of risk is the complete defense. Implied assumption of risk is analyzed as either one, limitation on the duty owed to the plaintiff, meaning the defendant does not owe a duty to protect the plaintiff against known risks, such as being hit by a foul ball at a baseball game, or more commonly, contributory negligence, meaning the plaintiff unreasonably encountered a known risk, thereby reducing or barring their damages under the state's comparative negligence rules. And wanton or willful conduct, the plaintiff's negligence will be taken into account in most states, even though the defendant's conduct was wanton or willful or reckless. However, the plaintiff's negligence is still no defense to intentional tortious conduct by the defendant. Page 44 is a negligence defenses table, and it is showing a definition of contributory negligence is the plaintiff's own negligence contributes to their injury. The definition of implied assumption of risk is the plaintiff knew of a risk of injury and voluntarily assumed it. Pure comparative negligence is the plaintiff's own negligence contributes to their injury. Partial comparative negligence is the plaintiff's own negligence contributes to their injury. But I think the effect is what's going to define it. The plaintiff's damage award reduced if their fault is below the threshold level. Otherwise, plaintiff's claim is barred. Usually this is like at 51% of a fault. Some of the partial comparative negligence states will not require a defendant to pay if the plaintiff is half at fault or more than half at fault. Pure comparative negligence, the effect of that is that the plaintiff's damage award is reduced by a percentage of fault attributable to the plaintiff, and it is irrelevant how much fault that is attributable to the plaintiff. In implied assumption of risk, the plaintiff's claim is completely barred, but in contributory negligence, the same as the effect in contributory negligence is that the plaintiff's claim is completely barred. Defense negated by defendant's last clear chance. That only applies to contributory negligence. It's inapplicable to implied assumption of risk, pure comparative negligence, and partial comparative negligence. And lastly, does the defense apply to wanton or reckless tortious conduct? Contributing negligence is no, but it's yes, the defense applies to wanton or reckless tortious conduct in implied assumption of risk, pure comparative negligence, and partial comparative negligence. I feel like I need an example because I'm not quite sure what they mean by that. Doesn't look like there was an example given in the module.